Good afternoon, all. I am very pleased to present Professor Allen Buchanan from Duke University. The minimum we can say is that Rome gave him a warm welcome. I am very pleased to present Professor never come today, from Duke like today. I know the work of Professor Buchanan since more than 30 years. Rome gave him I mean, translated in Italian his work on theories of justice and his work on secession. And I read with enormous interest his book, Justice, Legitimacy, and Self-Determination, which I think is one of the most interesting books in the area of philosophy of international law. Today, Justice, Legitimacy, we are going to discuss his book, I think is one The Art of Human Rights, in the area, which is an innovative and I think today fundamental book in this area. We will have many discussions, and I want to save the time. So I will give immediately the microphone to Professor Buchanan that will present himself his book in a short summary. Then we will discuss in order, first myself, then Professor Bifulco, then Tega, then Cherubini, and finally Pellegrino. Thank you.
Go very smoothly. I also want to thank all of you for allowing me to speak to you in English rather than in Italian. And I'll tell you a story to explain why I sympathize with the unfair burden that academics have to bear for whom English is not their first language. When I first started university at Columbia many years ago, at the end of the first week of classes, a professor called me aside and said, "I don't know exactly how to say this, Mr. Buchanan, but you don't really speak English." Now, you have to realize I came from the southern part of the United States, an area that was regarded as backward and ignorant and racist, all of which was true, unfortunately. So the professor required that I go to the language lab for students for whom English is a second language. The next day, I'm sitting at the booth with the microphone and the earphones, and there's a fellow from Nigeria on my left and a fellow from Iran on my right, and we're all saying, "The cat is on the mat." And eventually, after a semester of work in the language lab, I passed the test, and here I am today. So I sympathize with the burden that you have to bear in speaking in a language that's not your first language. Now let's see, how can we, good. Why another book on human rights? There are lots of books written recently by analytic philosophers on human rights. And the main reason is that I was dissatisfied with current work. I thought there were problems with it. I thought it was inadequate. And I won't mention the second item at the bottom. I'm kind of a compulsive writer. I can't think without writing, so that's probably the main reason. Now, current analytic philosophical work on human rights falls into a couple of groups. There are people that are sometimes called naturalists who think that the main task for a philosopher thinking about human rights is to develop a theory of general moral human rights, roughly something like a theory of natural rights. These people pay little or no attention to international human rights law, and they pay little or no attention to international human rights institutions. Then there are people that are sometimes called the political theorist. They deny that work on human rights should start with a theory of natural rights, and they exhort us to focus on the practice of human rights as it actually occurs in the world, and on the political roles or functions of human rights in that practice. But, surprisingly enough, they pay almost no attention to international human rights law or institutions. And you can read Charles Beitz's book, The Idea of Human Rights, and he says a lot about what the practice is like, but from just reading his book, you wouldn't know that law is central to the practice of human rights. Also, I think the political theorists have been quite thin on the normative issues. They haven't really addressed in a serious way whether various aspects of the practice are morally justified or morally defective, whether the institutions involved are legitimate or not, and more importantly, whether there's a good moral justification for having a system of international legal human rights. So here are my initial assumptions that I made as I approached the writing of the book. First, that one important task for philosophical work on human rights is to try to evaluate the practice, that is, to give a moral evaluation of it. And second, that international human rights law is central to the practice. I think of international human rights law as being the lingua franca of the practice. I don't think that there's any philosophical theory of human rights or any so-called folk theory of human rights that can play the role that the international law of human rights actually plays. Working for those assumptions, I conclude that philosophical work on human rights, if it's to help us evaluate the practice, has to do at least two things. It has to provide a characterization of the legal aspect of the practice, and it has to evaluate that. It has to give a kind of interpretation or understanding of the international system of legal human rights, and then it has to assess it from a moral standpoint. And the assessment includes not only evaluating the doctrine and the text, the norms, as it were, but also the institutions. Question: why have philosophers, naturalists as well as the political theory types, tended to neglect the system of international legal human rights? Well, here's my hypothesis. The naturalists hold what I call the mirroring view. That is, they believe that justified legal human rights correspond to antecedently existing moral human rights. They think that to justify including something among the international legal human rights, you have to show that there's a corresponding antecedently existing moral human right. And because they think that, they think of international human rights law as, in a way, rather trivial from a normative standpoint. They think of it as just the legal embodiment of the proper moral theory of human rights. The political types tend to think that the law is unimportant because they think that most of the real work of human rights gets done without the enforcement of human rights law by international institutions. I think that's a mistake for two reasons. One, some enforcement, in fact, most of the enforcement of international human rights law that actually occurs is not done by international institutions, it's done by domestic institutions, including domestic courts. And secondly, enforcement is only one way in which human rights can have an effect in world politics. There are many more subtle ways. So I don't think either of these are good reasons to neglect paying attention to the law and the institutions that support it. Now here's why I think the mirroring view is false. Remember, the mirroring view is the view that if you want to try to justify including some right in a set of international legal human rights, you have to first establish that there's a corresponding moral human right. You have to give a justification for the claim that there is such and such a moral human right. Well, first of all, generally speaking, valid or justified legal rights need not mirror moral rights. There are many cases of legal rights which look like they're perfectly acceptable, good things to have in a legal system that don't correspond to antecedently existing moral rights. Second, many international legal human rights can be adequately justified without first establishing that there's an antecedently existing corresponding moral human right. And one can provide these kinds of justifications without lapsing into consequentialism. That's something I spent a certain amount of time in the book trying to establish. I won't go into it now, but if it comes up in discussion, I'm happy to elaborate. Consider, for example, rights to physical security, like the right against arbitrary deprivation of life, which figures in virtually all of the main human rights documents, or the right to health, which also figures in most of them. Rights to physical security as legal rights can be justified by appeal to a number of different moral considerations, by appeal to their importance for individual well-being, for autonomy and opportunity, for security of resources, etc. Similarly, the right to health can be justified in a pluralistic way. There are a number of different moral considerations, not limited to there being a corresponding moral human right to health, which speak in favor of having a right to health as a legal right in domestic legal systems and in international law. One can appeal to the importance of access to health care and conditions for good health for individual well-being, for autonomy, for solidarity in the society, for social welfare because of the productivity effects of having healthy people, etc. Further, and this is a more controversial point, I think, some important legal human rights cannot be justified by viewing them as legal mirrors of pre-existing corresponding moral rights because, generally speaking, moral rights have a narrower scope of duties than legal rights. Why is that? Well, in the case of a moral right, and when we're talking about moral human rights, I think we're mainly talking about what are called claim rights, rights that have corresponding duties where the duties are owed to the right holder, the person that has the right. In the case of moral claim rights, an individual A has a right to X, to something, if and only if there is some aspect of that person's interest, the right holder's interest, that are sufficiently important to create the corresponding duties. That's what it means to say that the duties are owed, morally speaking, to the right holder. There must be something about that individual's interest or status that's sufficiently important to ground all of the corresponding duties for that right. But not so in the case of legal rights. It's true that legal claim rights have duties, legal duties, that are owed, legally speaking, to the right holder. But those duties need not be owed, morally speaking, to the right holder, independently of what the law establishes. In other words, in the case of legal rights, if you're trying to justify a list of corresponding duties, you don't have to show that the interest of the individual right holder or the individual right holder's moral status is sufficiently important to create the entire list of corresponding duties. Instead, you can appeal to the interest of others as well as the interest of the right holder. And that means that in principle, it's possible to justify legal rights that have much greater content, have much greater scope of corresponding duties than would be possible in the case of justifying moral rights. Here's an example, the right to health care. As it's usually understood, the legal right to health care, both in domestic legal systems and in international human rights law, has a more extensive set of corresponding duties on the part of the state, right, than could possibly be justified by appealing exclusively to the interest or status of any particular individual right holder. Now, why is that so? Well, usually the right to health care as a legal right is thought of as having quite extensive duties, including the duty on the part of the state to provide equitable access to personal health care services, to provide public health programs, for example, large-scale vaccination or immunization programs to achieve the public good of herd immunity to infectious diseases. The duties also include the duty to undertake large-scale interventions to reduce environmental threats to health, and on some views, especially on the part of those people who take the social indicators of health literature seriously, the duties include a duty on the part of the state, again, to undertake large-scale social interventions that constrain social inequalities that adversely affect health. Now, if you think of the legal right to health as encompassing those kinds of things, it's very hard to see how you could justify such an extensive and expensive set of duties simply by reference to the importance of the interest of any particular individual. After all, these interventions involve large-scale outlays of social resources. They involve large-scale restrictions on people's liberties, for example, with respect to immunization programs, mandatory immunization. In many cases, what's required is for the state to achieve certain public goods that are relevant to health. And it's very hard to justify supplying public goods simply by appealing to the interest of any particular individual. Now, I want to focus on how the naturalists go wrong, and I'll focus on James Griffin of Oxford as a sort of primary example of the naturalist and what I take to be the mistakes that they make. Griffin develops his theory of moral human rights, and then he does something very interesting. He goes through the list of international legal human rights in key human rights documents like the Universal Declaration of Human Rights and the Two Covenants. And whenever he sees a right appearing among those legal human rights, he crosses it out and says it shouldn't be there because it doesn't correspond to a right in my list of moral human rights. I think this is the height of arrogance. I think simply to assume that something can only be a valid or justified international legal human right if it happens to correspond to, your favorite theory of moral human rights, I think that's a bit arrogant because it begs important questions. It wrongly assumes without justification the mirroring view. By the way, Griffin never states the mirroring view, much less defends it. Instead, I think you can only make sense of what he's doing by the hypothesis that, in fact, he makes that assumption. Now, here's how I proceed in contrast. I adopt an initial posture of justificatory pluralism with respect to international legal human rights. That is, I don't assume the mirroring view. I don't assume that the only way to justify saying that such and such should be included in the international legal human rights is to show that there's a corresponding moral right. Instead, I leave myself open to a plurality of justifications. Now, there are moral justifications, but there are many different kinds of moral justifications other than just the one particular kind that appeals to a corresponding pre-existing moral human right. Now, remember, my ultimate goal is to try to answer the question of whether the existing international legal human rights system, or something roughly like it, is morally defensible, morally justifiable. But to do that, I have to give a characterization of that system. Here's my first attempt at characterizing what I call the initial project behind the creation of the system, or the basic idea. It's to develop a regime of international law whose primary function is to provide universal standards for regulating the behavior of states toward those under their jurisdiction for the sake of those individuals themselves, that is, not just for the sake of state interest, where those individuals are at the same time considered as social beings. Now notice that this characterization doesn't even mention the idea of rights. It just talks about standards that are supposed to be a departure from pre-existing international law, which really had to do almost exclusively with the interest of states and only considered the interests of individuals so far as they affected states. But it doesn't even mention the idea of rights. The basic idea does employ something that's closely associated with the idea of individual rights, namely the idea that somehow individuals are valuable in themselves, that they're important enough to warrant legal protection in their own right. Now, in fact, the International Legal Human Rights Project has assigned a prominent role to rights. If you look at the major human rights documents, there are lots of rights listed. But it's also interesting to notice that there are lots of norms listed in those documents that are not formulated in terms of rights at all. They're formulated simply as duties of states or as prohibitions, don't mention rights at all. That's completely puzzling unless you realize that the fundamental idea is, in a sense, more basic than the idea of fleshing out that basic idea in terms exclusively of individual rights. One of my tasks in the book is to explain why, if I'm correct about what the basic idea was, the form that the execution of the basic idea actually took gave a very prominent role to individual rights. Now, my goal is to characterize the international legal human rights system in a way that first is consistent with the main facts about it. It's sort of true to the way it is, but which also makes it morally attractive, that sort of puts the best moral face on the facts about the system. And then try to see whether, when it's characterized in that way, it's morally justifiable. And I argue that the characterization that fits those two desiderata, that actually reflects largely the facts about the system as it is, but also puts the best moral face on it, is one which characterizes the system as having two main functions. And both have to do with what it requires states to do with respect to those under their jurisdiction. First, to provide all with access to a minimally good life or a decent life, that is, to perform some basic welfare state functions. But this is left actually quite vague as to how extensive, how robust the welfare state has to be. The second function is to affirm and protect the equal basic status of all people within the jurisdiction of the state. So there's the minimal welfare function and there's the status egalitarian function. Notice it has to do with equality of status, not equal distribution. I don't think there's anything in the international legal human rights system that clearly endorses any kind of distributive egalitarianism with respect to justice. Now, that's the description that I give, but I also go on to argue that, in fact, it's quite fitting for the system to perform these two functions, the minimal welfare function and the status egalitarian function. Now, this is in contrast to what I think is the dominant view on the part of analytic philosophers working on human rights. Most of those philosophers only focus on the first function, the minimal welfare function. They formulate it in different ways. Sometimes they say that what human rights do, and all they do, is to protect basic interest or to help ensure a minimally good or decent life. Here I would include David Miller, Christopher Wellman, Andrew Altman, Margaret Moore, who's going to be visiting here later this month, James Nichol, and myself, formerly, before I saw the truth, before I had my conversion, right? Like Paul on the road to Damascus. It was a blinding light, and all of a sudden I realized this was wrong.
Rome. No.
That's right. That's right. It was not Damascus, it was Rome. Right. I think that you can't understand much of what goes on in the international legal human rights system and the practice that's anchored in that legal system unless you realize that international legal human rights don't just serve this kind of minimal welfare, well-being function, but they also serve this status egalitarian function. And I'd say quite a lot about this in the book, but I'm just going to summarize some of it right now. First of all, of course, they're the same rights are enunciated for basically everybody. And when the rights are said to be abrogable, that is, when they're said to be exceptions to the state's duty to enforce the rights, there's no discrimination as to the conditions of abrogation. The conditions of abrogation are the same for everybody. You can't say, for example, that rights to freedom of expression can be abrogated in the case of certain religious minorities, but not in the case of the majority. That's completely against the tenor of international human rights law. Also, there's equal access to remedies for violations of rights for all. There's equal and very strong due process rights for all. And there are strong rights, especially, but not exclusively, in the Racism Convention and the Women's Convention against private and public discrimination on grounds of race and gender. Now, you could have had an international legal system, just as there have been many domestic legal systems that didn't have all of these status egalitarian features. You could have a system which gives the same formal rights to everybody within the jurisdiction, but doesn't give all of them access to equal remedies for violations of the rights. You could have a system which gave the same rights to everyone, but had different and discriminating conditions of abrogation for rights. I'll give you an example of the former kind of system. In the Iranian legal system, for those cases in which the testimony of women is allowed in court, the testimony of women generally counts 1/4 as much as the testimony of men. Now that's clearly a violation of the requirement of equal access to remedies for violations of rights. The international human legal rights system goes out of its way to rule out that kind of discriminatory application or implementation of rights. Now, I said that I want to try to focus on evaluating not just the norms, the doctrine, and the texts of the international legal human rights system, but also the institutions. And Chapter 5 is a very long, probably too long chapter on issues of institutional legitimacy. And it builds on work on institutional legitimacy that I've done with the eminent political scientist, international relations scholar Robert Cohen, but I think it develops it considerably further. And there are two main points, and this is probably much too brief, but I'll come back to them in discussion if anyone wants to talk about it. First of all, I think of institutional legitimacy as an ecological idea. That is, the legitimacy of one institution can depend not just on the characteristics of that institution taken in isolation, but on how that institution relates to other institutions, perhaps to many institutions. Why is that? Because institutions can stand toward one another in relationships of reciprocal legitimation. One institution can contribute to the legitimacy of another, and vice versa. And in fact, legitimacy of some institutions may depend, at least partly, on the contribution that those institutions make to the legitimacy of other institutions. The second main idea in this chapter on legitimate institutions is that legitimacy assessments, making judgments that this or that institution is or is not legitimate, legitimacy judgments or assessments have a particular function. They function to achieve what I call meta-coordination. And legitimacy is something that's constructed, it's not discovered. Now, here's what I mean by meta-coordination. Just let me back up. So, okay. The idea is that the concept of legitimacy is a concept that's different from the concept of justice, and it's different from the concept of mutual advantage. We find ourselves often in a predicament where we need institutions, and institutions are valuable chiefly, though not exclusively, for their coordinating role. They enable the coordination of the actions of many individuals in ways that are generally mutually beneficial. But the problem is, for those institutions to work in that way, we have to support them. We have to defer to them. We have to sometimes take the rules that come out of them as content-independent reasons for acting. At the very least, we have to refrain from interfering with the operations of the institution. We need to treat the representatives of the institutions, the people who occupy the roles, with a certain kind of respect, if all of this is to work, if institutions are to do for us what we need them to do. But the problem is, there may be alternatives as to institutions, and what we need to do is to coordinate on some particular coordinating device, that is, to coordinate on some particular institution in a domain of operation, when there may be more than one that could do some kind of a reasonably good job. When we find ourselves in a kind of space where merely settling for an institution that makes us somewhat better off than the non-institutional alternative is not enough. That's not normatively demanding enough. But requiring that the institution be fully just is too much to demand. That's where the concept of legitimacy operates, between those extremes. And it's not as if we go out and discover that institution has all of the right characteristics to be legitimate, because what this really means is it would be discovering that we ought to support it. Instead, we have to give a sort of on-balance judgment, which we're capable of sharing with others, as to whether, at least for the time being, we ought to treat the institution with respect. We ought to support it in the ways that are required for it to function to provide the goods that institutions can provide. Now, seeing international legal human rights institutions as elements of a complex institutional ecology characterized by relationships of legitimation really changes the way we look at them. Sometimes in the philosophical literature, people say things like, well, look, human rights law couldn't be legitimate because it's not made by democratic legislatures. Instead, there are these highly politicized groups, usually beginning somewhere in the UN, that formulate draft declarations, and then there's a lot of political give and take and wheeling and dealing, and maybe eventually the draft declaration gets refined into a draft convention, and then there's discussion in the General Assembly, and there's more horse trading and bargaining, and then eventually enough states ratify the treaty for it to go into effect. But that doesn't look like anything like good lawmaking of the sort that we expect from legitimate domestic legislatures. I think this is just completely the wrong way to look at it, because I don't think these groups that draft human rights conventions are making law at all. Instead, what they're doing is making proposals for treaties with the understanding that states have to ratify the treaties, and increasingly more and more states are democratic, so their ratification actually has some normative significance. But then, of course, once they've ratified the treaties, the understanding is that the norms that are in the treaties don't immediately go into effect in the countries that have ratified them. Instead, there has to be a process generally of incorporation into the domestic legal system, and the domestic legislature, which we hope will have some of the marks of legitimacy, has to translate the abstract norms, with the help of the judiciary in many cases, that are found in the treaty into real law. Given this more complex picture, it's just a mistake to treat the bodies that create human rights treaties as if they were legislatures and then complain that they don't have the features of legitimate legislatures, so the process is not legitimate. Similarly, some people look at treaty bodies and say, look, these bodies are virtually impotent with respect to their enforcement powers. At most, they can sort of issue report cards against countries and say, well, you really shouldn't be killing all of these people or something. But all they can do is shake their fingers and request over and over again for states to reply to their reports, which they often don't do for years, years and years, if ever. Well, if you think that sort of being minimally efficacious in enforcement is a necessary condition for the legitimacy of these bodies, then you're going to think they're illegitimate. But they're not enforcement bodies. Instead, what they do is they create international fora. They create a space which enables information to evolve about the human rights performance of states, and then allows other actors to mobilize in a way that promotes enforcement, or at least promotes some kind of compliance. In other words, if you want to think of them as having enforcement powers at all, the enforcement powers are delegated. They're delegated to states for the most part, primarily to states. Okay, I've already said something about coercion. Here's what I mean by reciprocal legitimation. States contribute to the legitimacy of the international legal human rights system by using legitimate processes to translate treaties into law and providing enforcement, where enforcement also includes adjudication. The international legal human rights system, in turn, contributes to the legitimacy of states by providing an independent assessment of the state's treatment of those under its jurisdiction, and by obligating states to take the interest of foreigners into account. NGOs, I'm thinking of human rights NGOs, contribute to the legitimacy of the international legal human rights system and to the legitimacy of states. And this function that they play actually helps to confer legitimacy on the NGOs. That's another aspect of what I call reciprocal legitimation. Now, given my characterization of what the system is like and what its two main functions are, the welfare function and the equal status function, The question is it justified? Is it the kind of thing for which you can give good moral reasons for having it and for supporting it? Well, I think there are a number of different things that can be said in favor of having a system like this. Let's say a system like this because you might think that the system doesn't get some things right, but that it's sort of the right type of system. I tend to think that. First, it encourages the creation or improvement of domestic bills of rights, that is, of constitutional rights arrangements. Historically, this has been true. If you look at what happened from the beginning of the modern human rights era during the period of decolonization, when recently decolonized countries were forming constitutions, and even more especially when you look at what happened when the Soviet bloc broke up and many of those formerly authoritarian states became more democratic, new constitutions were developed that often included individual rights, and often they were explicitly taken from the Universal Declaration of Human Rights or from other, or from the two conventions, especially the Convention on Civil and Political Rights. Second, the system provides backups for failures in the implementation of domestic bills of rights. And this is true not just for states that are very weak on human rights, but even states that have some of the best records domestically with regard to human rights often have lapses when it comes to the case of women, or the case of gays, lesbians, or transgender people, or the case of migrants, or of some ethno-national minority. Third, the system enhances the legitimacy of the states that participate in the system, by providing independent adjudication of claims that citizens make against their own state. Fourth, the system contributes to better understandings of domestic constitutional rights, so far as those domestic constitutional rights purport to have universal moral grounding. In some constitutions, there are some rights which look very local and particularistic. The Swiss Constitution, for example, contains constraints on the making of beer. Okay. But in most cases, constitutional rights in domestic systems purport to be universal. They purport to be not just rights of the citizens of France, but the rights of human beings. Now, there's always a risk that if you're trying to conceive of the rights of human beings from the perspective of your particular national society, you may have an unwittingly parochial view. You may not really take the larger view. You may mistake some more local or parochial interest for genuine human interest. And so far as the international human rights regime includes an evolving discourse that has input from many different cultures and societies, other things being equal, it has some epistemic advantages in terms of helping us understand what rights should be like. Fifth, it supplies institutional and doctrinal resources for morally progressive developments of the humanitarian law of war, making it less statist. I mean, the humanitarian law of war is sort of an interesting body of law that developed quite independently from human rights law, and at least for much of its early development, it was simply viewed as a way of states making accommodation for each other's interest, with the idea that they all had an interest in limiting warfare in some way. But it was states' interests that were primarily at the fore. Later, you get a genuine humanitarian impulse with direct concern for the well-being of individuals. But I think that there's now a movement where human rights law is beginning to penetrate the humanitarian law of war, and to make it clearer that the main moral concern of that body of law is with individuals, not with state interest, and to make it clearer that the obligations that states have with regard to how war is fought are not conditioned on reciprocity. That is, that it's not that we're obligated to treat your soldiers well because you treat our soldiers well, but that instead it has something to do with the value and importance of the lives of those soldiers themselves, independently of their relationship to state interest. Sixth, the system constitutes a normative framework for characterizing, and perhaps for coping with, this is more problematic, genuinely global problems, threats to well-being for which individual states cannot reasonably be held accountable. Global warming might be one example. I actually think that the human rights discourse is better at characterizing the nature of some of the harms that may occur from global warming than it is with providing guidance for solutions. And that's not surprising because this body of law was primarily designed to fix obligations on states for how they treat their own citizens, right? And that's just not the frame of the problem of global warming. And seventh, I think this system can help correct for a structural bias of democratic politics, a bias against due consideration of the rights of foreigners. I mean, the good news about democracy is that it makes the leaders of a polity accountable to the members of that polity. That's the bad news too, right? Because it tends to make them exclusively accountable to those people, even at the price of not properly regarding the interest of foreigners. The simple slogan here is foreigners don't have the right to vote, so there's not much democratic accountability through the electoral process for taking the rights of foreigners into account. I think one of the things that human rights law can do is to allow democratic peoples to bind themselves to taking seriously the interest of individuals who are not in their polity. Okay, I'm just about winding down here. Now, there are a number of big issues that are left, and I devote big chapters to each of these two. One is the familiar parochialism objection. You often hear that, well, human rights is some sort of Western cultural imperialism. There's really a plurality of valid ethical views. How could anybody think that it's appropriate or tolerant to try to impose one set of standards on all states, given that there are many different kinds of moralities across different states? The second issue is what I call the supremacy issue, and I mention this with great fear and trembling because there are international lawyers present on the panel who know a lot more about this than I do, especially because they're experts in the relationship between domestic constitutional law and European law, where the supremacy issue is at the forefront, right? It's the most salient kind of issue. But believe it or not, most cosmopolitan analytic moral philosophers, people writing on global justice or on human rights, are completely oblivious to these issues. And roughly the problem is you have a domestic legal order, perhaps a very good one, where there's a comparatively good job done of respecting human rights. But then here is international human rights law, and international human rights law claims legal supremacy in the areas about which it speaks. So the question is, why should the citizens of a pretty decently rights-respecting domestic legal order defer to the legal authority of international legal human rights institutions or regional ones like the European Union, right? That's the question. And that's what this chapter is about, and I think it's probably going to look like great news to Americans and incredibly simplistic to Europeans. That's what I think. But at any rate, I think I've just about run out of time. So maybe 2 more minutes? Okay.
Yeah, don't move.
Let's think about this first big problem, the problem of ethical pluralism. This is a huge problem if you hold the mirroring view. So remember, the mirroring view says, really all the international legal human rights is the international legal embodiment of individual moral human rights. Well, that looks like it's pretty hard to justify if you come from the standpoint of morality that's a bit more collectivistic, that's not as individualistic in its values. Okay? This is not as much of a problem for my pluralistic view, because on a pluralistic view there can be a number of different kinds of moral considerations that can help justify having individual legal human rights, okay, having norms that take the form of individual rights in the law, even if some of those justifications are not really individualistic. They're not really, just attuned to a highly individualistic morality. Now, I think that there probably is some individualistic bias in the existing international legal human rights system. I don't think it's such a great bias that it makes the system unacceptable. And I think there are signs that what bias there is being mitigated to some extent. I mean, right from the beginning, international human rights documents, going right back to the Universal Declaration, included some collective rights, in particular the right of collective self-determination. But more recently, there's been a tendency to begin to take indigenous peoples' rights more seriously in international law. And one hallmark of the indigenous rights movement is that it has stressed group rights or collective rights. Quite independently from that, there's been, in some cases, interpretation either by courts at the national level or by treaty monitoring bodies of individual legal human rights in a more collectivistic way. The primary example is the judgment of the treaty monitoring body for the International Covenant on Civil and Political Rights under the optional protocol in the Lubicon Lake Band case. This was an indigenous group in Canada, and they were concerned that their traditional hunting and fishing grounds were being destroyed by development, and they went under the optional protocol to this treaty body, monitoring body, and the body rendered a judgment in which it said that the individual right to culture, which is mentioned in the relevant treaty, in the case of indigenous people, needed to be interpreted in a collectivistic way that had to do with preserving the collective property arrangements and natural resources that were the foundation of the culture. So there's a case where the system that was formulated in terms of individual rights actually had a certain amount of flexibility for being more sympathetic to collectivist concerns. Also, I think that even just from the standpoint of highly collectivistic moralities, there are great advantages to having a system of individual legal human rights at the international level. If you look at the history of the creation of the modern human rights movement, it occurred, in the smoking ruins of World War II and the Holocaust, at a time when many people were impressed that the greatest threat, not only to individuals, but to all groups within society, was an overweening state, okay? You think about fascism, you think about Nazism, about Japanese militarism. These were ideologies which either crushed all other collectivities within society or required them to be subservient to the state. So it wasn't just that these ideologies, when put into effect, damaged individuals as individuals. They destroyed valuable collectivities. Families, religions, ethnic groups, all sorts of groups were subordinated to this one super collective, the nation state. And I think it's very clear that part of the impetus behind creating the modern human rights regime was to provide international legal protections against that. And the primary way of providing the protection that was chosen was individual rights. And I think there are good reasons for that. And in the book, I argue why, paradoxically, oftentimes the best way to protect collectivist values is through individual legal rights, not through group rights or just exclusively through group rights. Okay, now the supremacy issue, just a word about that. Given the advantages for states and their people, and remember I listed 7 sort of advantages of having a system like this, there are good reasons not only to support this system, but to participate in it, where this means recognizing the supremacy of international human rights law. I don't think so much the problem is that of recognizing the supremacy of international human rights law. I think that's compatible with a proper understanding of sovereignty. I think the question is, how do you do it? How does a democratic, rights-respecting state open itself to claims of supremacy on the part of international law? I think that sometimes the way it's done is completely inconsistent with democratic principles and with the proper exercise of the right of collective self-determination, because sometimes it's done simply by treaty making as usual. You get a bunch of treaties, you get some executive agreements, and then the cumulative effect, which no one has discussed, which has never been debated, which has never been subject to any sort of robust democratic authorization, may in fact be, the cumulative result may in fact be a change of the domestic constitution. I think that's a serious problem. So my emphasis is on trying to think about the proper way in which the supremacy of international human rights law should be acknowledged. I don't think there's a good argument to say that it shouldn't be acknowledged. It's a question of how it's done, and I think that's an enormously difficult question. Now, I've said some good things about the system. I want to indicate that I'm not, completely over-optimistic. I think there are a number of problems with it. The biggest one, obviously, is under-enforcement, or more generally, poor compliance. There's biased enforcement. If you're a powerful state like Russia or the United States or China, you can get away with a lot more human rights violations than if you're a weaker state. Everybody knows this. I think also, as I indicated earlier, that the system is inapt for coping with gross disparities of power among states, right? It's not really designed to do that. It's designed to regulate the relations between states and their people, not the relationships between states. But of course, in our world, there are huge power disparities between states, and these power disparities produce all sorts of unjust results in the structure of global basic institutions, the nature of the trade regime, the intellectual property rights regime, in many, many different ways. Fourth, I don't think the system is very apt for helping solve versus diagnose global cumulative harms like global warming. Fifth, I think the system currently lacks adequate doctrinal and institutional resources for avoiding rights inflation. I actually think the European human rights system is beginning to develop, perhaps, some better resources for constraining rights inflation. But I think at the international level, almost everything needs to be done. Rights inflation can occur in two ways, either by multiplying the conventions or list of items in the conventions, or by overexpansive interpretation of items that are already there. I think both of these are likely to occur, and I think that's a serious problem. I also think, finally, that the current international human rights regime is doing a pretty miserable job with respect to immigration. And I'd be happy to talk about that with you during the discussion if possible. I have I do just a little bit of hands-on human rights activism on the southern border of the United States, and I am more and more impressed that the immigration problem in the United States is one of the two major human rights problems in the United States. The other one is the mass incarceration of people of color. But the horrors that the migrants face trying to cross the border in the United States is certainly up there. Thank you.
Thank you very much, Alan. I am Sebastiano Maffettone, Professor of Political Philosophy at LUISS. I say this because I know that there are people online watching, courageous people, but I think that should be very happy after your presentation because you were both exhaustive and brilliant, frankly, a rare conjunction. So thank you again for your presentation. I begin with a kind of family resemblance. I am a Southerner. As a matter of fact, I'm Napolitan. And I always took Italian as a foreign language. So, I mean, I've got the same problem we got in US, but in Italy. And imagine about English. It's a translation of a translation. So I must say that I read The Earth of Human Rights with enormous intellectual sympathy. It's a rich and powerful book. I completely agree with some theses within the book. First, human rights are an increasingly significant element in international relation theory and practice, the kind of lingua franca you mentioned before. Second, it's true that there is already a significant philosophical work in this domain, but it's also true, like you say, that the focus has always been on moral human rights. People like Griffin, but also Sen, discuss it this way. Instead, your book, The In System, and I think you are completely right, is on human rights law. Now, what I will try to do is to signal 5 points in which your position is different, but from the so-called political conception of human rights. And then I will present 7 small questions. Don't worry about the number, just because it's a complex book, so I need to understand better. But I must say it's something I understood during your presentation now, so perhaps I will be shorter. Now, let's take seriously the distinction between orthodox views, which we can call foundationalist, naturalist, or in your case, the mirroring view, and the political conception of human rights. I think that you are right. The naturalist views are arrogant and they cannot meet the challenge of pluralism. Instead, the political conception, in different ways by people like Ignatieff, Baetz, Cohen, I think it's more interesting from this point of view. First, I think we should define the political conception. I myself would define it through two different items. First, the political conception of human rights is that human rights are conceived as conditions of membership or inclusion in a general political society. Second, that these rights are rights that individuals do possess in virtue of specific associative relation. That's why they are political in the classical Rawlsian sense. Now, I think that even if you do not admit it, you are much nearer to the second group. Your view is near to the political conception of human rights than to the naturalist view. But in this, there is a problem, of course, because what is immediately evident is that the orthodox view maybe cannot resist the challenge of pluralism, and maybe it's arrogant, but it's after all a critical view. You have a critical standpoint from outside, a point from which you can criticize existing human rights, whereas the political view, from this point of view, it's more flat. It more or less accepts the existing system of human rights. And so you must make an extra effort to be critical enough. And I think that the extra effort is the main difference from your position and the standard political conception. Now, as I said before, I have 5 points in which I think you distantiate yourself from the political conception. First, of course, you put much more emphasis on the justification of the practice of legal human rights. Perhaps the equal status function and the well-being function are the most relevant innovation within this justification. But I think that the fact itself that you spend so much energies for justifying the existing system of human rights is very significant and problematic. A very interesting book like Baetz accepts the idea that you start from the practice, but doesn't make the same effort to justify the practice. Second, you give a larger interpretation of the function of existing legal human rights against what you call conceptual imperialism. In other words, human rights are not only constraints upon self-determination of the states, like the version Baetz Rawls, the so-called morality of states view. They are part of a more complex liberal egalitarian theory of international relations, based on an extensive interpretation of the equal status idea and the well-being function idea. Third, in your view, there is a space for a moral theory of human rights, but it's not the space traditionally taken by the orthodox view. It's not the space neglected by the political conception of human rights. Fourth, I already said that you are not concerned only with the limits of the state, the fact that a state that does not respect human rights loses self-determination, but you say that human rights protect normative agency in general, which I think is a very strong point. 5, clearly you extend the scope of the practice, including in the practice not only basic human rights, but also the work of courts, NGOs, transnational companies, treaties, and customary law. So these are the 5 differences I see from, all these differences imply a significant difference with the standard philosophical approaches, both in this case, the orthodox view and the political conception of human rights, with key different consequences with reference to sovereignty, duties, supremacy, and so on. But now I arrive to my 7 questions. Sorry for the large number of questions, just curiosity overcame prudence. The first question, I think it's very structural for me, it's very important. You justify practice in a very strong way through the idea of equal moral status and basic well-being. In this case, your theory becomes very similar to a theory of global justice. In my mind, instead, human rights function as a first institutional step toward a kind of theory of human rights. You get some institutional first point from human rights, then you proceed toward the theory of global justice. Instead, if you justify so strongly the practice, you already give a theory of global justice. Second, but this I got well when you explained today, but I think it's an interesting point anyway. It's not clear how much egalitarian and how much minimalist or sufficientarian you are. I mean, if I understand well, you are minimalist on welfare and egalitarian on status. That's your position, more or less. And that will be interesting to know what is the relation with the classic position, like Henry Shew's position of basic rights. I mean, the third point, of course, many states do not fall within the threshold for respecting human rights you mentioned. But it's frankly quite difficult to imagine any kind of intervention, also the most specific one, within your territory and political domain. If women in Iran are not considered full witnesses, what we can do, I mean, if women in Saudi Arabia cannot drive the car, etc. I mean, all these positions and other many positions like that concern different cultural traditions are very difficult to mitigate from outside. I mean, I think that only from inside they can be. And this concerns also the fourth point, parochialism. It would be very interesting to know in what sense legal rights are less parochial than moral rights. This is a basic question, I think. I think that you are right. Legal rights are less parochial than moral rights because there is some kind of convergence. But still, it's doubtful to think that we, I mean, there is one risk. You use the same argument that the orthodox view uses with that you call arrogant and that cannot challenge the pluralism, but one step further. You say that there is no cultural difference that counts at a level of human rights by using the same arguments that traditional philosophers use adopting moral rights. I don't know whether I'm clear. I mean, 5. This is another delicate problem. It looks like the first one. The relevance of your pluralistic justification for global justice. I mean, it seems to me that if you have this kind of justificatory pluralism with a convergence upon human rights, you get the overlapping consensus, and so the basic structure. So the theory of global justice is done, whereas we know that it's different from inside. It looks like political liberalism that concerns the nation state, but in international relations, where it's much more difficult. And here I have doubts, because I mean, it seems to me that we are still before it. The 6th point is another that you mentioned very clearly before, and this is the relationship between, and you treat very seriously in the book, between this general international law, its supremacy, and democratic states. I mean, I mentioned just one case, that's to do with the Italian budget case and the European Union. We had a conference in this university 1 year ago, more or less, because Italian democratic activities are very much constrained by the fact that European Union, oblige us to respect some budget constraints. It's true that there are, this does not concern direct human rights, but international law. How much we can admit that a democratic state can avoid this fundamental passage of democracy? There is no representation without taxation. The budget is a fundamental point of democracy in both cases. And finally, last one, concerns the legitimacy of international institutions. Admit that chapter 5, I think it's one of the best chapters of the book. At least for me, it interests me very much. But let's admit that what you call the meta-coordination view is not immediate to be understood. I think that when we speak of the practice, for all people accepting a kind of political conception of human rights and of international law, we have to put together a normative argument and a sociological argument. And we can call the first an argument concerning justice and the second an argument concerning legitimacy. If we want, and we follow Simmons, we can claim that the first way to resolve the problem is Kant's and the second Locke's. For Kantians, legitimacy depends from justification, whereas for Lockean, they are independent. Last week in Brazil, I had a long discussion, almost 2 days of discussion with Thomas Canlon about this problem, because Tim thinks that justification alone closes the argument. Instead, I think that you need something sociological, historical, to accept, to close the argument. And if you have international disagreements about justice, not about the good, but about justice, how can you solve them? The idea of Scanlon was that, there is nothing else that the force of the best argument, namely justification. I instead think that you need some kind of legal, sociological, historical support. And in this case, is legitimacy enough? Because legitimacy usually for democratic states, for liberal democratic thinkers, concerns consensus. Whereas here we need something, so to say, already given. In my own position, that I have no time to express here, but unfortunately for you, I will submit to you sooner or later, I use the word legitimation like a middle standard between justice and legitimacy, having the idea that you need a third between the two, which is both normative and sociological. The idea comes from people like Habermas and Rawls. They both transform something which is empirically important in something that is normatively significant. And what they transform from empirical to normative usually is liberal democracy. I try to use human rights like this third that goes between justice and legitimacy for historical and, but this is a complicated point. What I would like to question is the idea, I would like to know more, is the idea in which you put together the normative side of justification with the sociological or historical side of it. Thank you very much, and sorry for being so long. Now, we put together the... Sì, of course.
Make this in terms of human rights, but in fact, these bodies of political theory and law develop quite independently. So I think that there are lots of issues of global justice that are not dealt with by human rights enterprise as I understand it. Whether the human rights enterprise could be modified and expanded to accommodate these other areas, that's a very difficult question. I'm not convinced by that. Some people look at international law and say, oh, it's hopelessly fragmented. Well, what they see as fragmentation, I sometimes see as helpful modularity. Okay? It's not necessarily, lack of unity is not always bad. Sometimes, especially in a reasonably undeveloped system, lack of unity is good. If you have modularization, you can have incremental change and improvement in one area without having to change everything. And actually, from an evolutionary standpoint, that's extremely important. Anyway, I haven't done justice to half of what you said, but I really, I'll come back to some things if you want to, but I want to leave time for the other panels.
Thank you very much. Now, Professor Raffaele Bifulco, which is not only the prestigious chair of Diritto Costituzionale, Constitutional Law at LUISS, it's a traditionally very prestigious chair, but also has a very rare combination in his CV. I mean, it's both graduated in philosophy and law, so it's the best to evaluate all this stuff. And among his many works, I read the book on law and future generation, which is a very qualified and interesting book that I found very convincing and profound. But I don't want to take his time, so the word to Professor Bifulco.
Thank you. Thank you, Sebastiano. Well, I go straight to the point. There is no need to spend many words explaining the relevance of the studies of Allen Buchanan in boundary fields of philosophy and law. One of them is human rights, and you know that constitutional scholars look at them as an issue in which international law and constitutional law tend to overlap, or at least to interplay. So I found many reasons to evaluate the book, The Heart of Human Rights, as a major contribution. In my opinion, I have found at least two reasons. The first one is related to the object. I mean, to the way in which the author handles human rights. This book shed a light not only on the justifications of human rights, but also on the institutional problems surrounding human rights law, such as international institutions that write or that draft declaration on human rights, or the way national states implement the declarations, or also the way scholars and theorists study human rights. The second reason is related to the method. The author manages the various perspectives on human rights with masterly skill, I can say, setting out the most important problems relating to human rights and offering solutions that constitutional scholars should study carefully. I would like to discuss some important parts of this book, especially some questions that the author addresses in chapter 4, 5, and 6. Indeed, in these chapters, the author revisits problems that are interrelated to human rights issues and constitutional law issues. I will especially concentrate my attention on the, let's say, relationship between the national and international discourses on constitutions and constitutionalism and the Buchananian discourse on human rights. So let's say the key words for me in this discourse are constitutionalization of international law, denationalization of constitutional law, internationalization of constitutional law. So what are the main claims of these theories? Maybe we interplay, yeah? What are the main claims of these theories relating to the international constitutionalism? I will call them constitutional school. It's worth noting that over the years, constitutions and constitutional law have been used as tools for understanding the transformations of the international law, of international organizations, of the international regional regimes, and of supranational regimes. Moreover, as we know, non-state actors acting within states or even in a transboundary fashion are increasingly entrusted with the exercise of traditional state functions, even with core tasks such as military and police activity. We can think about the occupied Iraq in 1993. The main contention of the constitutional school is that constitutional principles and categories can serve to develop a new regime of international law. The theorists of the constitutionalization assume that the traditional tools used in the domain of international law are no more sufficient to work with the actual international legal system. This system, in other words, is something new, something that firstly appears after the Cold War's end. The basic premise of the constitutional school is that the international community is a legal community. Evidence of being the international community a legal community are the world order treaties. And we generally include the treaties on human rights in this kind of treaties. What is interesting is that human rights law have or can have a strong influence on constitutional democracy. In other words, international law has a strong influence on constitutional law. It isn't difficult to explain why human rights influence constitutional law. The reason is that human rights treaties and constitutions have the same content, at least a partial same content. It has the protection of the human beings from the public and private powers. In doing so, these two domains of law show a new interplay. On one side, constitutional law lends its main part, fundamental rights, main part or content to the international law, and on the other side, international constitutionalism recommends and strengthens efforts, legal and political, to compensate for, let's say, the ongoing deconstitutionalization of the domestic level. Chapter 4 shows and evaluates an interesting challenge to the idea, to the very idea of constitutionalism, so far as this constitutionalism want to exclude external influence on domestic constitutional democracies. Buchanan, we have heard, presents powerful reasons for having a system of international legal individual rights like the existing one. But I want to focus attention more closely on the most serious and frequently voiced challenge to international constitutionalism, the lack of democracy and legitimacy in the international law system. In few words, international constitutionalism breaks off the legitimacy chain, thus leaving without an answer the democratic deficit question. There are two different opposite approaches to the question, to this question. The first approach, call it the pro-international law approach, claim that we must accept the legitimacy deficit. This legitimacy deficit is an ongoing challenge intrinsic to any political decision-making process, regardless of whether it is of domestic or post-national nature. The second opposite approach, call it the democratic approach, says that the neglect of democracy does not come as a natural force. It is a consequence of a shift in attention and valuation from legitimacy to efficiency, from political to legal constitutionalism, from democracy to legal technocracy. So, what can we say about these two different ways of evaluating the same fact? In other words, at what point have we arrived? Must we go ahead along the road of the acceptance of the legitimacy deficit, or must we say, stop and go back at the very beginning of thinking about the legitimate production of international law? To answer the question, we have to read with great interest the chapter 5 of this book. Buchanan argues that the responses of the philosophical literature on institutional legitimacy are unsatisfying because, in his opinion, the same term, legitimacy, can be applied to the state and to non-state-like institutions. Philosophical literature has concentrated itself just on the legitimacy of state institutions, encouraging the conclusion that legitimacy is a matter of having the power to rule and to wield coercion. I can't resume the whole set of arguments Buchanan develops. The author argues that there is a general concept of institutional legitimacy that applies to both state-like and non-state-like institutions, to institutions that rule in a robust way, the states, to institutions that rule only in a weaker sense, as with the WTO, to institutions that don't rule at all. The author calls this general concept of institutional legitimacy the meta-coordination view and applies it to some of the key international institutions that create, interpret, and implement international legal human rights. The aim of Buchanan is to demonstrate that the legitimacy deficit these institutions are said to suffer looks less serious if we recognize two facts, two very important facts. The first one is that they contribute to the legitimacy of state in many distinct ways, backing up constitutional rights, facilitating collective self-binding through participation in international institutions. At the same time, their playing with this function contributes to their own legitimacy. The second fact is that they outsource key functions, including legislation, adjudication, enforcement to states that are in large proportion constitutional democracies and to other mechanisms for promoting compliance to NGOs. Many constitutional scholars evaluate these two facts in a very critical manner. The first fact would be the demonstration that the state is on the way of dismissing its traditional powers. The second fact is considered as a limit in the capacities of the international institutions. On this point, Buchanan offers to us a very different perspective. Rather than saying that international institutions are very limited in their capacities, he said, I quote, "We should view their capacities as including their ability to utilize the powers of domestic institutions and NGOs." In other words, suggesting an interesting analogy with extended mind hypothesis, he proposes to speak of the extended legal institutional order. I find this concept very interesting for the problem international constitutionalism. The two factual analyses ground an ecological view of the international institutions in the following sense. It is often not possible to determine the legitimacy of an institution in isolation. Its legitimacy may be a function of how it fits into a network of institutions. I think that Buchanan offers very useful instruments to constitutional scholars. The most important point of the chapter is that legitimacy is an ecological concept. Thereby, it's correct to say that for these international human rights institutions to be legitimate, they need not to be democratic. So the proposal of an ecological understanding of legitimacy can be the foundation of a new approach to constitutional issues regarding relationships on an ideal scale between horizontal loose market-like structure and a hierarchical state-like one. Indeed, it seems to me difficult to speak of an international constitution in a formal sense, because a complete constitutional charter at the moment is missing, no formal act of constitution making can be discerned, and the normative hierarchy is only at the moment rudimentary. So the concept developed by Buchanan can shed light on the legitimacy deficit whose relevance in the recent public discourse we know very well. The second conclusion I find very important is that the fragmentation and the lack of system of international human rights institution can be a virtue. We know that the international law is a compendium at the moment of parallel orders, and its constitutive process is horizontal. It resembles a legal patchwork, superficially seamed at the edges. The ecological perspective of legitimacy helps us, considering fragmentation and modularity, a right way to incremental change and to competition among institutions in ways that would not be possible in unified systems. The last point I want to discuss concern the so-called incompatibilist concerns, according to which constitutional democracy and international human rights law are incompatible. Buchanan identifies 5 different incompatibilist worries. These worries are very widespread in the United States, so that it's very interesting. Read an American critical voice like that of Buchanan. I try to summarize his contention, saying that it doesn't recognize a general incompatibility of constitutional democracies with international human rights law. At the same time, it doesn't deny the possibility of a clash. But in this case, the conclusion to draw is that acknowledging the supremacy of international human rights law is incompatible with the optimal functioning of the particular form of constitutional democracy that includes those constitutional structures. Anyway, Buchanan is much more worried about, let's say, the unjustifiable limitation on the exercise of collective political self-determination. Suggesting an analogy with federalizing process, the author draws on what he calls the meta-constitutional principle. In other terms, when some political changes are so important that the ordinary process for making political decisions are inadequate, the decisions ought to be made by the people through constitutional amendments. I would think that the direction suggested by Buchanan is not far from the idea of a compensatory constitutionalism on the international plane, in which the various levels of governments taken together can provide full constitutional protection. In conclusion, I have just a question. that draws on the reflection of Carl Schmitt. As we know, he argued that the adoption of universalism in international law would not do away with what he regarded as the core of the political. I mean, the determination of the public enemy and the ways to fight this enemy. So according to Schmitt, the question is, could the belief in universal humanitarianism and the international constitutionalism be seen as just another attempt to create a neutral, non-political ground upon which human interaction could take place? Thank you.
Thank you very much. Both of the speakers so far have been extremely charitable and generous, and they've made excellent points, more than I can respond to. I'm not a constitutional lawyer. I'm not a lawyer of any kind, so it's going to take a while for some of Professor Foucault's points to sink in. But on the Carl Schmitt point, this actually connects with something that Sebastiano brought up that I didn't respond to. There is a worry, of course, that any kind of universalizing program may be used to exclude and marginalize or even demonize those who are viewed as being in opposition to whatever the universal standards are. I think that one way that we can see that the risk of this is mitigated somewhat in the case of human rights is by focusing on actually a couple of different things. One, that as I understand it, human rights discourse allows for considerable variation in the local, that is national, interpretation and implementation of the universal standards. And that's facilitated by the fact that, because as I said, what the groups do that formulate human rights treaties is not create law. They create treaties which then can be used to build law in particular countries. And those countries, there should be room for some local variations in understanding, so that the universalism of human rights is not quite as extreme as it first seems. But secondly, I think it's very important to distinguish claims about whether someone is violating human rights from claims about whether it's justified to intervene in any way to stop them from doing what they're doing. And this resonates with something that Sebastiano said earlier. I agree entirely. All of the empirical evidence is that most major social changes, most of the time, come largely from within, and that efforts to try to impose, say, strict gender equality on many societies in the United States, in the world, would, impose them from without, would be disastrous and counterproductive, and that when valuable changes have been made, they've been made by cooperation between external forces and internal forces, with a lot of the leadership being in the latter category. So I think that if you have a very clear understanding of the distinction between the grounds for intervention, which are much more complicated, and the mere fact of human rights violations, and you realize that the universalization in human rights is really, in a way, less robust than it appears once you allow for this sort of local variation interpretation, this mitigates to some extent the worries that Carl Schmitt had. But I'm not a Carl Schmitt scholar, and I must confess I have an aversion to reading it, actually, to be perfectly honest. But one has to overcome these aversions sometimes.
So we go to another legal and constitutional interpretation by Diletta Tega from the University of Bologna and Nanterre. She works in constitutional law. She wrote about cultural identity, among other things, on cultural identity and religious symbols, and on le carte dei diritti, which is particularly in constitutional jurisdiction. So please, Diletta.
Thanks. So, among many other points, what I would like to focus on is the fact that your inspiring book critically evaluates tensions between the commitment to the constitutional democracy and the commitment to the authority of international human rights law, expanding the agenda for research on cosmopolitan theories of global justice. As you may know, part of the legal doctrine, let us think about Mattias Kuhn, Miguel Maduro, Sabino Cassese in Italy, argues, although with different perspectives and conclusions, that international law is an integral part of our highly imperfect constitutional universe, and that the relationship between domestic and international law is of mutual dependence. Their ideas are summarizing very well, I think, by very telling expression like law without nation, global administrative law, international constitutional law, constitutionalization of international law, and so on. I think that the goal of your book is clearly stated. I mean, to provide a framework for tackling the problem of the justification for having a system of international legal human rights, and to take the first steps toward determining whether it is likely that a convincing justification can be constructed. I must say that here I perceive an interesting coincidence between the considerations at the heart of your book and the contemporary debate within the public law lawyers. A debate that, on one hand, at least for what concerns the compatibilist side, as you would say, aims to sketch a general outline for the reconstruction of the foundations of contemporary public law, pushing for a cosmopolitan turn in constitutionalism. Chapters 3, 4, and 5 address the different stages of justification, and in particular, for what I was interested in, you evaluate the institutional legitimacy of the international human rights institutions, critically considering a set of related concerns that arise because of assertions of the supremacy of international human rights law vis-à-vis domestic law, including constitutional law. You affirm correctly, in my opinion, that there is good reason to be concerned about the impact of international legal human rights law on domestic constitutional structures, even though there is no incompatibility in principle between a firm commitment of constitutionalism and an acknowledgement of the supremacy of international human rights law. First of all, you clarify the distinctive features of international human rights law, for example, limiting sovereignty, ascription of duties to the state, the claim to supremacy. I mean, it exists within a context of legal pluralism with respect to its own status vis-à-vis the authority of domestic law. And then you provide a very useful list, in my opinion, of different incompatibilist worries, as you called, focused mainly on different ways in which international human rights law can impact domestic law. I appreciate that you wrote that there is a tendency among liberal cosmopolitan theorists that unreflectively assumes that constitutional democracy and the commitment to international human rights are in harmony. To be honest, this kind of unreflectively attitude is strongly criticized by the majority of Italian constitutional lawyers. To come back to the listed concerns, You rightly labeled them incompatibilist because who voiced them suggest that the problems identified are so serious that the proper choice is to refrain from acknowledging the supremacy of international human rights law. Rightly again, you recall the fact that the US has not ratified a number of human rights treaties. Let us think about the American Convention on Human Rights and the Inter-American Court of Human Rights, maybe due in part to the influence of the incompatibilist concerns, especially those that focus on the supposedly damaging effects of the judicial interpretation of international human rights law on domestic constitutional structures. And I can't help but think about the debate between Scalia and Breyer on the use of foreign law and the well-known Lawrence versus Texas case. But you cite also Rabkin on that concern. And I found very pertinent the distinction you have done between in-principle incompatibility and incompatibility under current conditions and practices. You explained that the concern regarding the lack of coherence of international law can be dissipated if international human rights law matures into a more coherent and determinate systems of law, as European human rights law actually is already well on its way to doing. As I have already said, you approach a subject that in Italy is arrived, in my opinion, a mature stadium, thanks to not only constitutional lawyers, but also to constitutional or ordinary judges. Though your focus in the book is mainly on the UN-based system, as Italian and European lawyer, I cannot refrain from recalling the British polemic about the European Court of Human Rights decision against the UK law on the ban for prisoners to vote, graphically summarized by the expression "bring rights back home," or the harsh critics about the far short of deliberative democratic authorization within the EU, in particular considering the severe economic measures that states like Greece, Portugal, but also Spain and Italy had to adopt in order to get helped by the EU institutions. And in particular, I would like to bring into the discussion an example of these difficulties, discussing here the role of the protection of fundamental rights enacted by the Strasbourg Court. That for us is a very sensitive argument, connected to the emancipation of international law from, as part of the doctrine of firms, the stricture of state consent. The increasing tendency of international human rights law to circumscribe how states should relate to their citizens, it is just an example of the fact that generation and interpretation of international law is increasingly taken away from the control of states. Moving from, let's say, a traditional constitutional perspective, the study of the protection of fundamental rights enacted by the Court of Strasbourg and the national judges shows that states find themselves subject to international legal obligation they have not specifically consented concerning rights questions traditionally addressed only by domestic institutions. For example, in Italy, beginning of life, all the problem about life, content of religious liberty, and so on. I admit that the European Convention on Human Rights seems rapidly evolving to a sort of cosmopolitan legal order, a transnational legal system in which all public officials bear the obligation to fulfill the fundamental rights of every person within their jurisdiction. The system was enacted by Protocol 11 to the Convention and the incorporation of the Convention into national legal orders. For cosmopolitans, the court's capacity to render justice to foreigners and to people who are marginalized by and within national systems like Roma or travelers, is a factor of special importance to the argument that a cosmopolitan legal order has emerged in Europe. The emergence of the systems of the system depend on many reasons, obviously, including the consolidation of constitutional pluralism at the national level and of rights cosmopolitanism at the transnational level. The first process puts in discussion traditional models of the national legal systems in which the notions of constitutional unity and centralized sovereignty overlap and reinforce one another. The second process generates a new transnational legal system in which the judicial authority to develop and enforce fundamental rights is decentralized. The European Court itself regards the Convention as a sort of transnational constitution, a very living instrument, but it does not exercise sovereignty within national orders. The Court's case law gains influence domestically, often, at least in Italy, because of the incapacity and the lack of political will to address topics that steers and divide public opinion by the parliament. I refer again to reproductive rights, for example, or same-sex partnership. The court has transcended rights minimalism grounded and expensive jurisgenerativity, as Stone Sweet says, within national legal orders. While imperfect and still maturing, I think that the conventional regime meets significant criteria of effectiveness. It succeeds in raising national standards of right protection, even if it is not always true. It has been crucial to the success of transitions to constitutional democracy in post-authoritarian states in many states of the East Europe. The court's primary mission in Europe is rendering justice to individual claimants. Nonetheless, the European Court performs many of the same functions that national constitutional courts do. The court confronts cases that would be classified in the context of a domestic law as inherently constitutional. Within national systems, elected officials and judges have gradually abandoned centralized sovereignty while institutionalizing complex forms of rights pluralism. In principle, judges and other state officials could forge a cosmopolitan legal system on the basis of shared legal norms, practices, and understandings. The optimistic and easy picture I described, though, leaves unresolved a list of questions that Italian legal system represent, I think, quite well. Let me recall at least few of them. How the content of rights change, shifting from a national dimension with clear juridical, historical, and cultural ties to a space loose from that kind of belonging. I don't know. Is it always desirable that rights content refer to the interpretation gave by the international judge? Is there a link between the decline of the democratic legislator, common feature of Western legal systems, and the growing activism of international judges? Here I'm referring to what Dieter Grimm once called external culmination versus internal erosion. How much weight has to be recognized by national legal systems to the international judges? National and international levels corresponding to constitutional and international law can really cooperate in order to assure a more effective protection. Obviously, these are too many questions, and it's clear. But in particular, I think that the internal protection of human rights risks to mitigate the development of differences and the ties with minorities groups that, together with the central role recognized to the legislator, are one of the main features of the affirmation of rights at national level. Part of the doctrine theorized that judicial protection in anticipating and even replacing the political decision represents a sort of dangerous instrument through which imposing the so-called judicial colonization. Indeed, it seems at international and national level that not always the content of human rights represents a common ground. The existence of different judges of rights, national and international, brings, as Miguel Maduro says, to a cross-fertilization of legal concepts, a change that has to be conceived as an enrichment, obviously, but at the same time as a sort of rarefaction of the legal categories at stake. I think that cosmopolitan constitutionalism is an intriguing descriptive model able to embrace an important part of the complexity of the legal contemporaneity, for sure. But at the same time, if it's true that constitutionalism, with the capital C, lost the traditional principle of sovereignty, it cannot be reduced to a rights-based philosophy. Indeed, it cannot disregard the constitutional national dimension, the national citizenships, the political element. It is still very true that national judges occupy an intrinsically different position because of their legitimacy comes from the political community, and it is based on juridical and political values of that community expressed in the legal documents that they have to implement. Their judgments are based on legal parameters that derives from a democratic decision. To sum up, as I said at the beginning, I really found inspiring your book because I found a kind of parallelism of problematic and of a discourse of dialogue that we have as constitutional lawyers. And from a legal perspective, I think, I'm not sure, but I dare, that the example of the rights protection granted by the European Court of Human Rights, that is something very close to our experience, in particular concerning the recognition of rights that steer and divide public opinion, shows that we have still to reflect deeper on the modalities of the recognition of rights, not only about their justification, but for us, for our perspective, we have also this problem. Thanks.
Well, again, I thank you, and I feel completely out of my depth. This was It's just that I think this is an enormous problem at the level of the very best democratic states. It's not just a problem that occurs once we get to the Strasbourg Court or once we get to Brussels, right? It's a problem that's already undermining democracy even in the most representative, best constitutional democracies. I think that in the United States, for example, a lot of people still labor under the fiction that American citizens are governed by laws that are created by their legislative representatives. For the most part, they're not. They're governed by regulations that are attempts to implement laws that were passed by representative legislatures. But the distance between the regulatory law that actually operates on the ground and what the legislators approved of, not to mention the weak links between the so-called representative legislators and the people themselves. This distance is so great that I wonder sometimes if there are any existing democracies. I think to put it most radically. So it may be that I'm not sufficiently appreciative of the democratic deficit problem at the international or regional European level for two reasons. One, I'm reacting so strongly against the hostility of most American constitutional lawyers to any kind of foreign law. And two, I'm so despairing about the problem of the democratic deficit, even in the best democratic states, that it's just somehow not news to me that there's a problem at the supranational or international level. Now, this is an apology, not a justification.
Thank you very much. The apology. Frankly, is also outside the states. That's another point. I mean, you cannot limit politics to elections and something like that. Perhaps there is a wider concept of politics. But this I will not discuss now, but maybe later on, drinking something. So I give the word to Francesco Cherubini, which teaches human rights in the very prestigious Department of Political Science at LUISS, and as a forthcoming book on human rights. And prego, Francesco.
Thank you, Sebastiano, and thank you, Gianfranco, for the invitation that has given me the chance of better know the work of Allen Buchanan, which I have found very interesting, and especially in the part of the book concerning the limitations of the international system of protection of human rights. You speak about 5 limitations, and while I was reading about them, I was wondering if some of these limitations are true, proper limitations to the international system itself of protection of human rights, or most likely of international law in general, and if some of these limitations have already found a possible solution or a growing solution in international law practice, and especially in the practice of those organs that has been given the duty to protect human rights within the universal and the regional conventions. I would like to focus on 3 of these limitations. The first one, I'm quoting, the effectiveness of the international legal human rights enterprise, which depends largely on states ratifying treaties. And as you say, of course, states are free to refrain from ratifying treaties or to ratify them with reservations. Indeed, regarding this limitation, it is true, as you recognize further in the conclusions, that there are some norms, some rules of customary international law which protects human rights, and I would add with a special form of protection, because these rules belong to the jus cogens, so to the part of customary international law which is not derogable by treaties in general. It is also true that the regulation of the reservations to human rights treaties is a bit different, it is quite the opposite to that concerning treaties in general. And the final result of this different regulation is a derogation to the principle of consent. But you go farther in your book because you suggest a more radical option, which is consistent with this premise of sort of break of the principle of consent, which is in international law what an eminent professor of constitutional law would have called the antico feticcio, the ancient talisman, the principle of consent. You suggest the introduction of a new norm of international law by virtue of which a supermajority of ratifiers can impose legal obligations on non-ratifiers. States against states that have not ratified a treaty. I consider it, as you consider it, legally possible. And as you say, not contrary to the nature of international law. You're not persuaded?
No, I agree. It's not. It's because international law is not fully consensual, right? That's the point. But I mean, I wasn't advocating that we do this. I was just saying this is a possible direction, in a sense, extending the category of use codes. But anyway, go ahead.
Okay. Yeah, it is quite difficult to convince states to abandon completely the principle of consent.
And I think it would be dangerous at present.
Oh, okay. I will have regarding this suggestion, this new norm, I would not allude to a new norm, but more to a new method in international treaties regarding human rights, which would allow the respective organs of control to develop human rights norms by a majority system of decision. And indeed, you make the example of the European Union. You make an example of method, because the introduction of a new norm is quite difficult because it's a procedural norm in the customary international law, but it is a key point in the international organizations, treaties, international treaties that creates international organizations. It is also true that such a method is not completely unknown to human rights system because it is practiced in some of the treaties protecting human rights, especially, I would say, only in regional treaties. It is protected by what I would call a sort of Trojan horse in these treaties. And I'm referring here to the judiciary supervision system. And of course, the example, the Palmer example, is the European Court of Human Rights. Why? Because creating a judiciary supervision system, such as that of the European Court of Human Rights, could bring the system, could strengthen the system much more than a majority system of decision, because it could develop the rules by interpreting them, notwithstanding at all, or almost at all, the consent of all the member states of the convention. Of course, except the general consent regarding the acceptance of the judicial review. For what concerns the second limitation, I totally agree with you. The failure in compelling states to act when another state fails to fulfill its primary duties in dealing with human rights, because what is now the developing solution, in other words, the responsibility to protect, is quite dangerous, is very dangerous to me, because, as you say, this concept is subject to serious abuses, and we have many examples of what have been done, but also what haven't been done. In the first category, for what was the first version, unrefined version of the responsibility to protect, the humanitarian intervention, the case of Kosovo, but also the case of Libya, or, by contrast, the case of Syria. Of course, it's another example. Yeah, more or less, yeah. And this is the final observation I make about these limitations to the system of protection of human rights, the unclear position of non-state actors. To me, this limitation is on its way to be partially solved, since in the recent years, doctrine in the case law of those bodies, and especially of the European Court of Human Rights, has developed the doctrine of positive obligations. States are not only responsible for what they do, of course, but also, and this is quite obvious, for what they do not do. But in what they do not do, there could be also the prevention of violations committed by private actors. For example, drug cartels. For example, paramilitary forces. And I think that is all.
Well, thank you again. Thank you. Well, thank you again, and I'm so happy each of the commentators have brought up different aspects of the book, and that's helped a lot because my summary obviously was quite inadequate. I'm very much grateful that our last speaker mentioned this other limitation of the current system, which I didn't list in my presentation, but which is in the book, and that is the fact that the system was really designed first and foremost to assign obligations to states with respect to their, as it were, official treatment of those under their jurisdiction. But there are many non-state entities, from global corporations to terrorist groups, which have a huge impact on human beings that are not covered in some obvious way by that understanding of the obligations. And the development of the doctrine of positive obligations, I think, is extremely important. And this is yet another reason why I want to learn more about the European human rights system. I also like this suggestion that in terms of mitigating the limitation that the system largely works through the ratification of treaties by states, that as an alternative to a kind of supermajoritarian procedure for extending jus cogens, instead it may be both more feasible, because it's already beginning to happen, and also maybe normatively better to think of these changes coming about through jurisprudence, basically through the developing jurisprudence. Now, this connects actually with something that Professor Tega said that I wanted to come back to, that and again it connects to the idea of a democratic deficit that was brought up earlier. I worry sometimes, and as I take it that you do, that even though judicial interpretation has some of the virtues that Professor Cherubini mentioned, that there's a risk that judicial interventions in the area of human rights will short-circuit the democratic deliberative process and the legislative process. And in the United States, people often make this complaint. It's just that I think they make the complaint about the wrong judicial decisions. There are still people who say that, Brown versus Board of Education was was premature. I think it was about 300 years too late, but that's the most important desegregation decision. But I think there may be other cases where actually judicial intervention may short-circuit a democratic deliberative process that could have issued in legislation that might have been both better from the standpoint of social cohesion and maybe even better in terms of the content of the right specification than a judicial intervention. And again, what I worry about is that even though the European Court of Human Rights is by far the most developed judicial system for adjudicating human rights claims, I still wonder whether sometimes its grasp, its reach exceeds its grasp. That is, that it hasn't yet developed sufficient discipline in interpretation, and that sometimes it's drawn into rendering decisions when it would have been better if it just didn't render a decision at all. It seems to me the U.S. Supreme Court has a lot more discretion to refuse to hear cases. I mentioned this in the book. And now, if that discretion is used wisely, it can be a very powerful curb on rights inflation. But it seems to me that in the European system, and you know so much more about it than I do, there's both a need for developing sort of doctrinal constraint on rights inflation and just some simple procedural devices like more latitude in refusing to hear cases that would help and maybe it's just too early to think that this should have happened yet. I mean, you can see the jurisprudence developing, and the question is the court at the right, does the court appreciate that it might be better sometimes to wait to get into areas after the jurisprudence is further developed and the discipline is more developed? Is it sometimes reacting and rendering decisions when it shouldn't? And if so, how could you mitigate that? I mean, something has to do with the culture of the judges. It's not just an institutional matter, it's a cultural matter. But I'd be interested to know what any of you think about that issue. I didn't formulate it very clearly. But.
Thank you. Now, Gianfranco Pellegrino, who teaches political philosophy in the very prestigious Department of Political Science at LUISS, is a moral and political philosopher, an expert of Bentham. He wrote many essays on moral and political philosophy. Prego, Gianfranco.
Thank you, Sebastiano. I think I'm going to be a bit circular, but I think in a virtuous way, since I will come back to the beginning, the starting of the book, which is a brilliant book. I agree with all the commentators. I enjoyed reading, but there is this very starting point, which is the mirroring view, which I would like to indulge a bit on. Since I'm partially, I have a lot of, that's the mirror. I have a lot of quotations, okay, and I will skip them since the book, we have read the book. I have two qualms about the mirroring view. First, I think that it could be unpacked in different ways, and only one of the ways is what is relevant to you. So my first question is, okay, which is exactly the sub-mirroring view that you have in mind, and I will show you some unpacking. And also I have some qualms about the strong of your sweeping rejection. I think that you can reject a part of the mirroring view, but I'm less sure that you can reject another part. Let me show my interpretation. It seems to me that you have in many quotations many mirroring view. There is a functionalist view, okay, according to which international legal human rights law, LR, should realize a set of human moral rights. And then there is a content mirroring view to the effect that the content should mirror, some legal rights should mirror the content of a moral right. And there is a justificatory mirroring view according to which legal rights are grounded in moral right. Now, first of all,
let me interrupt you.
Yeah.
I agree with 1 and 3 and reject 2.
Okay, so my idea is that one of your claim is that neither 1 nor 3 entail 2. And 2 is to be rejected, while 1 and 3 could be kept. So that's okay. As to justificatory mirroring view, it seems to me that, again, it can be subdivided in 2. And you can have a view which is what I will call the necessity view, according to which legal right can be justified only by an appeal to a moral right, and moral right are the only possible justification for legal right. Appeal to moral right is necessary in order to justify legal right. Seems to me that you reject these by endorsing a pluralistic view, according to which moral rights are merely one justificatory ground and one purpose for legal right among many. Okay, that's okay. And there,
could I interrupt you then for just a second on the necessity view?
Yeah.
Focus in on the necessity view again for a moment. I think that's actually ambiguous. There are two different ways you can interpret that. I'd be interested to see what you think. it could mean that whatever your justification is for legal human rights, if it's a sound justification, there has to be some reference to some moral human rights. Okay, I'm agnostic about that. That might turn out to be true. It might turn out that that the only sound justifications require reference to a right to equal status or equal respect. That's quite possible. But what I reject is the idea that for every, that the only legitimate moral consideration in justifying a legal human right is a moral human right of some kind, not necessarily corresponding with moral. That I reject. But I actually am agnostic in the book as to whether it might turn out that in the end, the best justification for various international legal human rights will in some way refer back to some moral human right, but not necessarily one that corresponds in any direct way to the legal right. Does that make sense?
Yeah, it's complicated. Since my second contention is that you have also another view that you reject, which was I will call the necessity and sufficiency view, according to which there are people supporting the idea that legal right can be justified only by an appeal to moral right. Moral rights are the only possible justification for legal right. Moreover, an appeal to moral right is sufficient to justify legal right.
I don't think most people wouldn't hold that.
Okay, so seems
not all moral rights
yeah,
should be legal.
seems to me that you have an argument against that, against the sufficiency view.
Well, I think that for some international legal human rights, like the right to health care, as they're usually understood, a justification that only appealed to a corresponding moral human right
it's insufficient. Okay, and I will focus on this. So, okay, this was the background till now. There is kind of justificatory relations among the claims, but okay, what I will try, this is an unpacking of a quotation. You have many claims, and this is my rendering of some of your claims. You say, okay, both moral rights and legal rights are Offeldian claims, correlative to duties. And then you say that duties correlative to moral rights are directed and solely subject-grounded. And the meaning of this is that their necessary and sufficient grounds lie in one or more feature of the right holder whose moral importance is enough to ground the correlative duty.
Now that's for moral human rights.
Yeah. And then you say that, okay, since this is not the case in the case of some legal rights, for those legal rights, such as health care and so on, moral rights are not sufficient as a ground.
Well, one interruption. It's not that I say they're not directed. They are directed in a legal sense. That is, in terms of the legal character of the right, the correlative legal duties are owed to the right holder. Sure. But they're legally owed. They need not be morally owed, and consequently they need not be justified merely by appeal to the interest of that individual.
I think that this can be said, quotations, let me skip, can be said in this way. You say that legal right correlates with duties grounded in interests starred, since, okay, not only interest but autonomy, we don't want like to endorse Rath's theory about interest. So interest star is whatever feature. Okay, so legal right correlate with duties grounded in interests other than the right holder interests.
Or in addition to.
Okay. And this could be, seems to me, spelled in this way. The different interest view, the above, can be interpreted as claiming the interest other than the right holder can be the only ground of duties correlative to legal right. And this is due to the fact that some duties have costs that cannot be justified, namely outweighed by the importance of the interest exclusively of the right holder. And then you say that, okay, those duties could be grounded in the interest of large numbers of people, which are different from the right holder interests, and whose importance justifies the cost of extensive set of duties.
I'm not sure I'm interested in endorsing this view, because I tend to think that, that what can be invoked to justify the duties in the case of these legal rights is both the interest of the individual right holder, but it's also important to appeal to the interests of others.
If this is the case, I'm very glad, since I suspected that this should be the case, or possibly my mistake, but let me show how this could be the case, and also let me show some problems in the large numbers view. That's the point. It seems to me that, okay, quotation, sorry about that. Seems to me that there are at least two ways of interpreting the large number views. One is aggregative, merely aggregative. I can say that there is a number of people whose interests are able to ground certain duties. And this number is larger than a minority of people benefited by those duties, but it's not necessarily equal to the whole of the audience. There is a big number of people that can have interest grounding this. This is aggregative, obviously. I'm aggregating. And another interpretation is, I have a figure in which I will show how the interpretation could show that each of the interests of large numbers of people equally contributes to the grounding of certain duties, because discharging even very demanding duties is justified when entire populations of people can all be benefited. Each interest involved adds the same amount of moral importance to the whole. And since we are believing in the egalitarian status, we should distribute equally this. Okay. So it seems to me that, okay, differences between considering the grounding, a difference could be considered this is a duty, an extensive set of duties. And then we have, one is the moral right holder, which is narrow in scope, okay. And then we have other people simply having interests. And we have more than 3 people, we have n people. So the aggregative story is so. We have a very large group of people whose interest can ground the duty, and the right holder interest is not considered. It can ground, but it's not enough. While the fairness story is that in this way, all the interests are considered as grounding. No one is able alone to ground, but all they are doing the work. Now, I'm going to finish. I'm going to reason on this. It seems to me that the aggregative view entails that some minorities could be sacrificed. And it seems to me that in the section on consequentialism, you are rejecting this. You are saying, no, I am not a consequentialist, and so on and so on. So the interpretation should be fairness view. Now, the fairness view entails that the right holder's interest equally contributes to the grounding, along with the other people's interests. Accordingly, if this view is true, the idea that the only ground of the legal right should be, it's false. So, okay, it seems that we agree on this. Okay, so duties correlative to legal right are grounded also in the right holder interest, as well as in the other people's interests. And this is plausible, I think, especially if we consider duties such as those involved with health care, education, due process. It's plausible to say that those duties equally benefit anyone, and this benefiting is the grounding relation, okay? They promote the interests. Even though nobody's interest alone can be a ground.
I think it's in principle possible that you might have a justified right attributed to a particular individual when that individual's interest played no role at all in justifying the right. For example, the right of a sort of fiduciary rights, the right of a parent to make certain decisions for the child might be justified exclusively in terms of the interest of the child. And the interest of the person to whom the right is attributed, the parent, might not play any role whatsoever in justifying the directed duties toward the parent. But
but I'm not sure that this is the case, since after all, if the interest of the parent is nothing in the justification, I could give the right to another person. Possibly there is an interest of the parent in being the trustee or okay. So it could be yeah. So okay, but I think that okay, and the RAS definition and your use seems to me is that okay, there is different interests involved. Okay, but this is something I think that we agree. I would like to know something about the insufficient weight view, the idea that all those interests cannot have a sufficient weight alone to justify such legal rights. Okay, so the fairness view entails that the right holder's interests alone are unable to grant correlative duties to legal rights, but no other interest alone is able to do the grounding too. So the view is true in a sense. No right holder's interest is able to ground duties correlative to legal rights such as healthcare and so on and so on. But now consider this view. Consider exactly the insufficient view. I have a question here. Since in framing this view, you seem to imply that the costs in terms of liberty, constraints and so on involved in the extensive sets of duties correlative to some legal rights cannot be outweighed by the interest of a single right holder, of a single person, even though they can be compensated by the interests of large numbers of people. Now, considering again, this compensation could be puzzling if we consider the fairness view, but okay, let's assume that this is the case, but it's not clear whose costs and which costs are at stake. Again, I think that we can interpret in two ways. You speak of duty of states, and this could be taken literally. States have the duties to promote very complicated legal rights such as health days and so on and so on. Is it sound to say that the cost of this for states is greater than the advantage for the interest of even a single right holder? It seems to me that states are perfectly able to bear those costs, and accordingly the interest of a single right holder is a sufficient ground.
I'm not thinking of the cost to the state.
Okay, so assume another interpretation. We go on to be in agreement, and so that's not a good show. We should disagree sometime. Okay, it might be argued that the relevant duties correspond to the duties of citizens in supporting and participating in state institutions promoting certain rights, taxes, for instance, okay. Now consider this. Assume that this is the right interpretation. The duties that you have in mind seems to be those involved in supporting, in doing my part in the working of institutions promoting welfare, some civil and some political rights. Assuming that those institutions promote rights equally addressed to anyone, who pays the cost coincides with who benefits of the right. If so, it seems implausible to say that the costs in terms of liberty are higher than the gains. The alternative cannot be that between assuming on oneself the cost of institution building for the sake of venturing certain rights and living free in a desert island. Rather, the alternative is between giving one's contribution to the working of rights, promoting institutions and giving up the benefits of being protected. This cost cannot be higher than one's interest. So it seems that the insufficient Consider this quotation. You have a quotation, I should do this. You have a quotation in which you say that, okay, whether an individual A has a moral duty, D, to do X, and whether it is justifiable to require A to do X, can depend on whether A has reasonable assurance that others are going to fulfill the duty. And then you say that in the case of legal right, we have this assurance. So discharging legal right, it's not very costly, but I wonder whether the existence of institutional cooperation can ground moral duties, and those moral duties can ground moral rights. There is also another quotation in which you consider that we can have some duty of beneficence to channel our beneficence in an efficient way, okay, through institutions. And again, assume that ought implies can, but it seems that the fact that we can do this can imply some oath. And so there is no an insufficient weight claim. It seems to me that after all, the interest of a single individual could ground legal rights. So the construction, let me finish. The construction is that, okay, your rejection of the necessary insufficient view depends on at least the insufficient weight view. It seems that insufficient weight view has some problems, so possibly you can have the necessary, but not the necessary insufficient.
Okay, this is very interesting. I guess I think that there may in the end be just a terminological dispute here. I'm not sure. But it seems to, I'm not interested in, you seem to be focusing more on whether the cost to any particular individual citizen is fair or something that could be reasonable for the individual citizen to bear. That's not the issue that I'm focusing on. I'm focusing on really a question of whether the benefit that the legalization of this particular right would bring to any particular individual is so important in terms of that individual's interest as to justify the social cost, the large social cost of implementing the right. I think it is a different question. I'm not focusing on whether there's a duty of individuals to bear those costs, although I think it seems the question. Well, I'm focusing on the duty of the state. The question is, take for example an aspect of the legal right to health care that involves the achievement of some large public goods that require huge expenditure of social resources and also require massive restrictions on the liberty of various individuals. Okay. Anything from immunization programs to efforts to reduce social inequalities that produce ill health in those in the lower part of the social hierarchy. It just seems to me that it's difficult to imagine that the interest of any individual by themselves are important enough to justify that expenditure of social resources and those massive restrictions on the liberties of so many people. On the other hand, if you can appeal to the interest of many individuals, then it seems to me it's not difficult to justify that. I mean, it's hard for me to imagine, let's say, the coercive provision of public goods, of any public good I can think of, just on the basis of the benefit that I would derive from the existence of the public good. Is that, I'm not sure I'm answering. Maybe I'm missing your point.
Well, but if this is the way, if this is the way of putting, you are simply a consequentialist, since you are distinguishing the sum of people being disadvantaged from a single person losing, okay? But the idea is that we should consider rights that are equally distributed. So any one of the people paying is also gaining. So public expenditure should be subdivided for taxes for any person, okay? So in a sense, what I'm paying, I'm gaining. If you are not considering that there is a difference between, if you're not aggregating, if you are simply considering a universal and equal distribution of rights. So if this is the idea, it seems to me that there is no big difference between what I'm gaining participating to a big system of healthcare and paying some taxes or having some restriction of liberties.
Well, I mean, let's go back to Raw's first example of this, the right to freedom of expression, right? He says the benefit of having the legal right to freedom of expression for any individual is not particularly great. Instead, the benefit comes, the major benefit comes from having lots of people with the legal right to freedom of expression and the kinds of activities of criticizing the government, democratic deliberation, et cetera, that can arise from many people having that right. But it's not possible to justify everything that's required to make that right, legal right, a reality simply to appeal to the benefit that any individual would get from it. Isn't that Roz's argument? Maybe I'm
Let's go with the discussion.
Thank you again. I think please do not abandon the room, because there will be a small refreshment afterwards, just to continue the discussion if you want, or to forget the discussion if you want. I'm sorry that people online cannot intervene, but before going to that, there are many scholars inside the room, so if there are questions, I think it's a good moment to ask them before Professor Buchanan will be completely exhausted.
I'm already exhausted. A long time ago.
Look at it. So perhaps if there is some urgent question. Otherwise,
I am at a disadvantage because I haven't read your book, but it's just a curiosity arising from your exchange with Gianfranco. I was wondering if the kind of situations that you have in mind do have some similarities with situations which H.L.A. Hart describes as situation in which arises a duty of fair play. That was the idea that Rawls sold on when he developed the idea of justice as fairness in his... Right. Situations in which in order to have a right, you need before to have a practice. And there are several people involved in the practice, and there are, each one of them is benefiting from the fact that the practice exists. And Hart says, in a situation like this, you can claim that a right arises to claim enforcement of a practice from people who try to try to free ride on the fact that other people are observing the rules. I'm wondering if that situation which you were discussing with Gianfranco has some similarities with this idea, because in Hart's mind this doesn't seem to be a consequentialist justification, because it was put in the framework of a fairness justification, not a consequentialist justification.
Well, I tried to be somewhat minimal and modest in what I say about the grounding of duties, and I took it to be widely accepted, Raw's analysis to be widely accepted, that is, that to justify saying that someone has a right, it's necessary to show that there's some features of the interest of that person to justify the grounding of the duties. Now, I agree, that's a different... Actually, it isn't so widely accepted. Well, okay, maybe I'm being parochial again. Maybe I'm... Yeah. Well, okay, but it's just that... Yeah, okay, but let's go to... That's fine, let's go to the choice view. I mean, suppose the choice view is supposed to somehow explain, or at least be compatible with the idea that the duty is owed to the individual, that we're talking about claim rights, okay? And so the idea is that, in the choice theory, the idea is that the individual who's the right holder, as Hart puts it, has a chain in his hand, and he can either activate it and compel the duty performance by the other or not, okay? But the question is, why is it that that individual controls the duty? Okay. And I think that so far as the choice theorists give any explanation of this, and Carl Wellman might be one example, they tend, at least implicitly, to say pretty much what Raw's does, that it has to be something about the status, having autonomy or something like that, or the interest of the individual right holder that explains why it is that individual who controls the corresponding duty, why it is to that individual that the duty is owed. So I think that the point I'm trying to make, now maybe I'm missing Gianfranco's point, maybe I haven't made the point, but I think that the point I'm trying to make, if it's valid, works both for choice theorist and for the interest theorist. But the other question, the question about grounding rights via some notion of fairness in a practice one's participating in, this comes back actually to something that Sebastiano said. I mean, in one sense, it looks like that won't work for human rights if you think of human rights in the way they used to be thought of by the naturalist as rights that people have simply by virtue of their humanity, because that seems to be ascribing rights to them independently of their participation in some particular practice. On the other hand, the membership idea, right, the idea that somehow human rights are those that define your membership status in a particular political entity, is much more sympathetic in some ways to this practice-based grounding. I'm worried about the practice-based grounding because I'm worried about people being excluded from practices, not having a chance to participate in ways that would generate obligations of fairness. So I'm worried about any sort of reciprocity basis for human rights because I think it would defeat one of the historical purposes of developing the idea of human rights. But I'm just going to have to think more about what you said. I may be not getting the point. I mean, in some ways, I'm inclined to say that I can agree with you in this sense. I do think there's such a thing as a natural duty to contribute to institutions which can provide rights for everyone. And I think there are some limitations on that duty. There has to be some sort of prospect of reciprocity, et cetera. And so in a way, I mean, if your point is, look, once we have the institutions in place, then the cost of the duties is acceptable from the standpoint. I guess I can agree with that. But I still think that's compatible with saying that in the end, what justifies the duties is not simply the interest of that individual. It's the interest of that individual in taken together with this complex fact about institutions and about the fair distribution of the burdens of providing the legal rights for everyone. That's why I wonder whether it's maybe more of a terminological difference. Let me ask you this. Do you think it's possible to justify at least some important international legal human rights without appealing to a corresponding antecedently existing moral human right? And do you think that in the case of some international human rights, like the right to health care, you have to tell a bigger story than merely pointing to the importance of having health care to any particular individual?
Is this a question for me?
Yeah, it's a question for you.
Is this? I think this is not the way we suppose that the thing. Not for, but if there are other, I will answer if there are no other person. Sorry, since okay. So sorry about politeness.
So I think if there are no other questions, we can stop here. It's been a formidable afternoon and a beautiful early evening, but we must stop here. We must avoid the night. I mean, Professor Buchanan has been so generous of himself. But
my brain feels like a big
you must forgive us at least for two reasons. The first is that it's the first day you speak here. We want to celebrate you and your beautiful book. And the second is that we Italians, especially Southerners, are convinced that foreigners think we do not work enough. So we always over-exercitate our functions. For this reason, please forgive us, and thank you very much.
I have to mention that the cover of my book is from a watercolor painting that my wife painted. And I'm very, very proud of it.